In their article, Legal Change and Sentencing Norms in the Wake of Booker, The Impact of Time and Place on Drug Trafficking Cases in Federal Court, Lynch and Marisa Omori conclude that local legal practices diverge across place and become entrenched over time such that top-down legal reform is largely reappropriated and absorbed into locally established practices. The United States Supreme Court cases U.S. v. Booker and U.S. v. Fan in 2005 and Pepper v. U.S. in 2011 ruled that the federal sentencing guidelines are no longer mandatory, merely advisory in determining criminal sentences in federal court. These decisions have had the cumulative effect of judges considering a broad range of sentencing factors in determining an appropriate sentence, including those not specified in the guidelines or in conflict with its policy statements, leaving judges free to use their official discretion in imposing criminal sentences other than those prescribed, so long as they both begin with the guidelines calculations and then explicitly state their reasons for any variance from the guidelines range. Lynch and Omori limit their analysis to drug trafficking because since the inception of the guidelines in 2009, drug trafficking was the single largest category of sentenced cases in the federal system, and drug trafficking offenses grew dramatically more punitive under the guidelines, more so than any other category of offense. And drug trafficking cases are particularly subject to a range of mandatory minimum sentences that have been enacted by Congress since the 1980s and remain in full force, even after the guidelines lost their authority. Lynch and Omori realized that actors with the power to put law into action will reshape it in ways that serve their institutional purposes and reinforce their legitimacy. No formalized rules govern the degree of reduction in minimum sentences, nor define what qualifies as substantial assistance, so these values are subject to variation across sentenced defendants, prosecutors, districts, and time. They found little evidence that judges' recently increased freedom to sentence outside of the guidelines is the primary cause of any increases in unwarranted variations in drug trafficking sentence outcomes, and instead observed an important message being sent to policymakers that the guidelines prescribed sentences are on the whole too harsh and inadequate in accounting for all relevant sentencing factors. In the end, they suggest that federal lawmakers revisit statutory minimums as to their appropriateness as a sentencing tool, and even consider mechanisms for tempering prosecutorial discretion at the multiple decision-making stages in which they hold considerable or sole power. Case selection, charging recommendations, and recommendations for substantial assistance departures to better restore equilibrium in the federal criminal justice work group.